Now, the major sports teams, sports leagues in North America and especially the United States do have a lot of control. They have a lot of monopoly power. But you have the Sherman Antitrust Act, which the goal of which is to prevent teams from getting too much or from having monopoly power. And so there are times when this law limits the abilities of these leagues. So the biggest case to be brought in terms of monopoly power was American Needle versus the NFL. Now, in kind of the background on this case, in 2000, the NFL terminated its leasing agreement with American Needle and other manufacturers so it could strike a executive deal with Reebok. Now, American Needle sued them, claiming that the NFL violated antitrust laws by acting as a monopoly. American Needle ended up losing this case, and all appeals were denied. Now, this is where it gets a little bit funny, because even after all that, the NFL, who was being sued by American Needle, joined American Needle in asking the Supreme Court to take up the issue. Okay? So why would they do that? The reason why is they saw it as an opportunity to expand the league. And they wanted to see how far their collusion could actually go and legally go. And so, with the NFL and other sports leagues, yes, you have the individual teams, but you also have the league acting on behalf of all the teams in many circumstances. So the NFL wanted to see how far they could take it. So they went with American Needle and said, look, let's get this Supreme Court, okay? Okay, American Needle, they said, all right, yeah, sure, sounds good. Now, the ruling of this ended up being that the Supreme Court ruled that the NFL could negotiate broadcasting rights and licensing agreements as one. Okay? So basically, they said they could act as a monopoly. The NFL appealed this. So again, this gets weirder and weirder. So the NFL appealed it. And they were claiming that the league was not 32 teams, but it was one. It was one league. So by bringing it to the Supreme Court, the NFL hoped that any action the NFL took would fall under a monopoly instead of collusion. Okay? So with collusion, you have individual businesses working together. Which is not allowed. That'd be like price fixing. But a monopoly does have more rights. Okay? So what ended up happening was that in the end, the Supreme Court ended up agreeing with the lower courts, and they kept the rights limited to broadcasting and licensing. So they said that the NFL could negotiate as one, basically cooperate with each other, but only for broadcasting and licensing. So they did limit it. But, if that would not have gone that way, if they would have agreed that, the league was not negotiating on behalf of all 32 teams, essentially colluding, if they said that was fine, then the NFL could have had more protections than they do. Okay? So this is just one example, but it's, the leagues need to be very careful with how they approach different negotiating and ways of doing business, because they are technically, because you have for example, with NFL, you have the 32 individual teams, but you have one entity negotiating for all of them, which technically is collusion if you're talking about any other industry.